All right. You all hear me?
Yes, Your Honor.
Great. I'm Judge McBurney. For those of you I haven't met, this is a bench trial on damages in the civil case 21cv350363. Plaintiff is Piedmont Heights Condominium Association. I've entered an order of default judgment in favor of the association. And we set this hearing down now several times, and my apologies to Mr. Finnemore and Mr. Lee for having to reschedule this several times because of complications in my calendar, but here we are. Why don't we make clear who is on for both sides? Ms. Fox, you're a court reporter?
No, I'm the community association manager for Piedmont Heights.
Fantastic. So we've got a witness. Then we're ready to roll. Mr. Finnemore, you represent Piedmont Heights and you've got a witness, Ms. Fox.
Yes, Your Honor. And I'll also testify with respect to the attorney's fees. You can't see her. She's off camera. I didn't want to confuse anyone, but I have an associate here just observing today. I don't know if you need to meet her, but she's just watching today.
All right. Hello, associate. Nameless associate.
Her name's Allie Poole, Your Honor. That was very rude. I'm sorry.
Okay, Ms. Poole, you got to assert your name in the firm. And Mr. Lee, how are you, sir? I can't hear you, sir. We need to work on your audio before we get started.
I was able to hear him earlier, Your Honor, when it was just myself, Ms. Fox, and Mr. Lee. I said good morning, and he was able to say good morning.
Okay. And I think he can hear us. Mr. Lee, raise your hand if you can hear us. Okay, so you can hear us. I got your chat. Just take a minute and see what you need to do to get the audio working. We will not start till you're ready.
Hello.
Hey there, Mr. Lee. How are you? Can you hear me?
I can hear you, but for some reason you don't hear me.
I don't know if you want to maybe try dialing in with your phone. I can hear you, but it sounds like you're really far from the microphone.
You hear me better now? Better now?
Yeah.
Better now?
Yes.
Okay, thank you.
Fantastic. All right, Mr. Lee, I'm Judge McBurney. I don't think we've met. Am I pronouncing your last name correctly?
Correct, sir.
Okay. Now you are free to represent yourself, Mr. Lee. The case is a matter that the association brought against you and I'm pulling up a document here. It's being slow. Tracey Lee. What is Tracey Lee's relationship to you?
Tracey Lee is my wife. And
Okay.
She absent today because she's taking kid to school. So I feel for both me and her.
Well, I'll hear from you. You legally can't say things on behalf of Ms. Lee.
Okay.
So I'll be hearing from Brandon Lee, but not from Tracey Lee today. Okay.
That sounds good. Thank you.
All right. So Mr. Finnemore, why don't you get us started and we'll go from there.
Thank you, Your Honor. This case involves a claim for unpaid homeowners association assessments pursuant to a recorded declaration. The association seeking damages related to those unpaid assessments, interest, late fees, attorney's fees, costs. The association is also seeking judicial foreclosure of the property located within Piedmont Heights. Sort of the procedural history is a little windy, Your Honor. You seem to be very familiar with it. But since it's so closely tied to the fact that we've incurred nearly twice the amount of legal fees we ordinarily would incur, I'd like to just go through it real quick so we know how we got here.
Sure.
When we initiated this case, we believed the owner of the property to be an individual named W. Alexander Morrison. We knew when we filed it that he was deceased. So we began our efforts by reaching out to his heirs, his estate, trying to figure out, why assessments haven't been paid. There were some payments coming in, but we didn't know where from. And we quickly learned that the property had been foreclosed. I found the advertisement for the foreclosure. I believe also at the same time, Mr. Lee had begun contacting me. So that's when we moved to amend the complaint to add Mr. Lee and Mrs. Lee as parties to the complaint. We ultimately got the lender to record their foreclosure deed. So even though the property closed back in 2012, we had no idea that Mr. Lee was an owner until 2021, around the time when we were amending the complaint. So we moved to amend the complaint as required, and we also moved this court to order that both of the defendants file an answer. We then dropped Morrison from the complaint since he was deceased and no longer had anything to do with the property during the relevant times of delinquency. And then Mr. Lee filed what appeared to be discovery responses on behalf of himself and Tracey Lee, which also included a counterclaim. We moved to strike the counterclaim because it was really just in the name of Tracey Lee. We moved to strike that answer and counterclaim, which the court granted. We moved for default as to Tracey Lee. And then since it seemed that Mr. Lee was really only disputing the amounts owed, he didn't contest ownership, he didn't contest being responsible for assessments. Really, it was just the amounts owed that he was disputing. We've requested this damages hearing, which you've granted.
Okay.
We're going to present, I have two witnesses. I have Ms. Fox to testify regarding the assessments, late fees, interest, and the significant amount of payments that Mr. Lee has made to the account. We're not saying that no payments have been made. There have been significant payments, just not everything that's owed. And also I will testify regarding the attorney's fees. In advance of the hearing, I filed a declaration certification of authenticity. That's under the rules of evidence, which would permit me to admit the account ledger without a live witness. I really only do that so that we have everything in front of us and so that I give and put notice to the other party of what I'm filing, what I intend to rely on. I actually have Ms. Fox here to authenticate the documents, but if Your Honor would permit, really the essence of the rule is that we can authenticate that without having her testify. I'll leave that to you when I move to admit it. And then I also filed the attorney's fees, which I am live and present to testify regarding the reasonableness. Mr. Lee, and I don't want to get ahead of the objections. He'll have the opportunity to lay his own foundation. I will object to the documents as being hearsay. We'll get there when we get there. But really, even if Your Honor were to look at them, they're essentially saying the same thing that I'm saying, that he's made significant payments, but he's even admitting that there are periods of time for which he did not pay assessments. In fact, it appears to me, and again, we'll hear from him, I don't mean to jump the gun, it appears that he's even admitting that he has not paid $4,000 worth of assessments. So it'll be our position that that regardless of what he's paid, he hasn't paid everything, and then we're entitled to the amounts being sought.
So let me ask a few questions. That's very helpful. And I do have Ms. Niles, as she always does, put everything in one easy place for me to find. So I've got a folder online of plaintiff's exhibits and defense exhibits, which we can, so when you get to them, if you get to them, I'll be able to pull them up. You can also do screen share. That's fine with me as well. Or I may share my screen and say, is this what you're talking about? But I do have your affidavit of attorney's fees, a document called CS, May 5th, 2022. And then, as you mentioned, your certification of business records. I don't think you're going to have an evidentiary foundation issue to get those things in, but belt and suspenders, you've got Ms. Fox here as well. So we'll work through that. Are you seeking payment? I guess I should ask it differently. Is it your position that Mr. Lee and his wife were in some way liable for outstanding amounts from Mr. Morrison, or that would have been somehow resolved through the foreclosure sale through which I guess Mr. Lee acquired this? Or is Mr. Lee on the hook, not just for amounts he has not paid during his ownership of and occupancy of the unit, or is it both?
Great question, Your Honor, with a very clear answer. No, we are not seeking anything that was owed prior to the foreclosure. In fact, this delinquency we're showing really arose in 2017, well after the property had been foreclosed, more than 5 years later. So there's no issue with respect to the former owner, except for the fact that we were spinning our wheels and basically duplicating work because we had no idea that Mr. Lee was an owner at all.
Right. So it's actually two more questions, not just one. And I want to ask it now because I may not remember. Are you seeking from Mr. Lee some share of attorney's fees that were accrued because this is going to come out the wrong way? You couldn't figure out who to sue. It may not be Mr. Lee's fault that you sued Morrison. And if it cost your client, I'm making the number up, $1,000 before you figured out, actually, you know what, the guy we need is Lee, meaning Mr. Lee. Why is it that Mr. Lee ought to, unless you show me he was hiding and obstructing, how is he liable for the legwork it took to figure out he was openly and notoriously owning and occupying the place?
Right. I mean, he I guess, twofold. One, the association had no reason to believe that W. Alexander Morrison was not the owner. By all accounts, public land records showed that W. Alexander Morrison was the owner of this property. So there was no apprehension. We knew who to serve and who to pursue because that's what the land records say. And it wasn't until after we filed the complaint that we learned of Mr. Lee's ownership. Now, Mr. Lee, on the other hand, had been provided a deed to record and never did so.
Okay.
And this may be off record, and I don't know if Your Honor wants further affidavits on
No. That helps me understand that your firm did what it always does, which is let's see, what did the land records say? Your client says, look, the owner of record is Morrison. You confirm that this is who we need to sue, but we've learned maybe Morrison is deceased, so it's the estate of and his heirs. But any careful check of the public land records would have revealed nothing about Mr. Lee being the rightful owner. Which doesn't mean he wasn't the rightful owner. There are consequences of not recording a deed, one of which might be you're going to be hit with some extra attorney's fees as someone who's aggrieved about the nature of your occupancy brings suit. All right, last question for now, and then I promise I'll let you get started. Maybe the most important. The numbers are going to be what they are, and I'll enter an order in the end if I find that there is an amount owed by Mr. Lee and his wife. Are you, Mr. Finnemore, in a position to work with Mr. Lee such that if he says, all right, I don't want to have to move. Judge just said I owe X. I'm going to give you that X. Would you be in a position through your client to say, well, then we're not going to foreclose? Or has your client already said the history with Mr. Lee is too fraught, and so we're not interested if he shows up with the amount owed plus a care package? We're not taking it. The way we're going to get our money is by foreclosing.
One of the greatest satisfactions of my job, Your Honor, is to resolve issues like these without having to go with a nuclear bomb of foreclosing someone's home. I've expressed to Mr. Lee on multiple occasions that if he were to relay a settlement offer to me, I would present it to my client, and with the hopes of trying to resolve the matter. Again, he's not saying he hasn't missed assessments. There's some amount that he's willing to pay. The question is, how close can we come to making my client whole?
Yep.
So yeah. I mean, I don't have the authority alone to make that decision, but again, my preference is always to resolve these things and to have each party walking away feeling that the matter has been amicably resolved and that there's no future problems going on.
Got it. Okay. Let's dive in. Well, wait, let me make sure. Mr. Lee, do you have any questions so far? There'll be an opportunity for you to make argument, maybe present evidence if your evidence is admissible. I was asking Mr. Finnemore a few questions just so I understood where he was trying to go with this hearing. It's a hearing to which he's entitled because of the default judgment I entered. Is there anything you want to ask me about before I have Mr. Finnemore start his presentation?
I would like to have some time. I would like to have some time to present and explain on my behalf.
Definitely. That you will have that turn. We start with plaintiff. So I'll hear from Mr. Finnemore. When he's done, I'll see what it is you want to share. Okay. Great. Mr. Finnemore.
Your Honor, having laid a foundation for authentication and admission of the Exhibit A to the Declaration of Certification of Authenticity, I move at this time, Your Honor, that exhibit be admitted into evidence, if not already.
Well, let me get that in front of me here. So the exhibit you're seeking to admit would be what looks like the ledger for the unit about which we're having the hearing.
Correct, Your Honor. It says Piedmont Heights Condominium Association in bold at the very top. And then it starts with the date of January 1st, 2017.
And to tie it back, and this may have been what you just said, to your declaration, which was filed on May 6th, it's Exhibit A to your declaration.
Yes, Your Honor. Yes.
Okay, got it. Any objection, Mr. Lee, to the admission of the ledger?
Well, what I'm looking at, they lately provide me with the more detailed information, but all I'm looking at an old 5 month in 2017 and the whole year in 2018, and the difference between 2022.
So let me put on the screen what we're talking about, and you can tell me if you are talking about the same thing. All right, you see that?
Yes, I do see this, yes.
Okay, I know it doesn't have your name on it. It says W. Alexander Morrison at the top, but this is a business record that Mr. Finnemore's client says they routinely keep in the course of their business, and he is asking me to admit it for the purposes of this hearing. I'm only showing you one of the pages. It looks like it's 7 pages long. It's not moving. Here is the last page, so it goes all the way through May 1, 2022, there was an assessment of $253.58. So my question to you is, do you have any evidence rule objection to the admission of what's known as Exhibit A to the declaration?
So they sent me that, and I tracked the record. So it looked like I make the payment, but maybe bank, I don't know what's the problem here. I set it up the automatic payment with Wells Fargo. So it looked like I did not pay 5 months from February 2017 to June of 2017 and the whole year of 2018, and maybe not up to date with the total amount for 2022. So
Okay.
I paid the same amount because I don't get any notification or letter, anything from associate say that the fee were increased.
Well, we can talk about that. I have a real narrow question right now, which is simply, are you objecting to this document coming into evidence? Not that you say the document is correct or incorrect. That's not my question. You may think, hey, some of these numbers are wrong. But Mr. Finnemore is saying, Judge, this is a business record that my client keeps. And under the rules of evidence, because it's relevant, it ought to be admitted.
No objection. No objection.
No objection. All right, Mr. Finnemore, it's in.
Thank you, Your Honor. May I swear in my witness?
You may.
Ms. Fox, please unmute. And please raise your right hand. Do you swear that the testimony you're about to give represents the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the court.
Delethea Fox,
And where are you currently employed, Ms. Fox?
Heritage Property Management,
What's your position there?
Community Association Manager for Piedmont Heights.
As part of your responsibilities, are you familiar with the document that the court shared with the screen a moment ago? Is it still up, Your Honor?
I can put it back up. I took it down so that we could see Ms. Fox. Would you like it back up?
As long as she remembers what she just looked at.
I do. Yes, I do. I am
Okay.
familiar with
Thank you, Ms. Fox.
I'm familiar with the account ledger, yes.
Who are the current owners of the property? Actually, is it a true and correct copy of the account ledger for the property known as 1413 Summit North Drive, Atlanta, Georgia, 30324?
Yes, it is.
Okay, and who are the owners of this property?
Currently, the owners are Brandon and Tracey Lee.
Okay. Is this account delinquent for unpaid assessments?
Yes, it is.
On what date did the account first become delinquent, or at what date are we going with for the delinquency date?
February 1st, 2017.
Okay. Now, how much you've reviewed this account ledger and you've done some math in terms of how much has become due for assessments that are owed.
Mhm.
What is that total figure?
That total number is $15,251.90. That is over since 2017. So would you like the breakdown of it?
Your Honor, would that be helpful to you?
When you say breakdown, you don't mean per year, but the breakdown would be principal, interest, late fees, et cetera?
No, Your Honor. I think she intends on going through the assessments for 2017 were this times this many months. It's on the ledger. It's pretty much self-explanatory. So, but unless Your Honor wanted to hear that.
No, I don't need to hear that. She's vouching for the accuracy of the ledger, and I'm looking at it now, so I can see that.
Okay.
Thank you, Your Honor. How much is owed on this account for late fees over that period of time?
$1,299.73.
Okay. Were there any other administrative expenses incurred by the association, other miscellaneous costs of collection incurred by the association in handling this account?
Yes, and that equals $171.
Okay. How much is owed for accrued interest over the time of this delinquency?
$1,721.59.
At what rate was interest accrued?
10% per annum.
Okay. Now, there's some significant payments on this account too, aren't there?
Yeah. He paid about $11,040.
Okay.
Since February 1st, 2017.
Has the association also incurred attorney's fees and costs in this matter?
Absolutely. Yes, sir.
Okay. Your Honor, just to briefly recap, the witnesses testified to assessments through May of 2022 of $15,251.90, late fees of $1,299.73, additional miscellaneous administrative costs of collection of $171, accrued interest of $1,721.59, less payments of $11,040.
So the first figure you gave me doesn't match what is on the ledger. You said 15,000 and something, and the ledger entry, the last ledger entry from May 1 was the assessment, a monthly assessment. So those would be the monthly COA dues. And they haven't been paid yet, but it looks like Mr. Lee was automatically paying on the 7th or so of the month. But that total figure is 12,336. What's the difference?
The difference could very well be that all of the attorney's fees aren't added as of yet. The difference is also the HOA fees now are currently $253.58, and he's been paying $241.50.
I see that he didn't upgrade, but the number. Let me do this so we're not. So I can.
Your Honor, I can help. I know exactly what you're asking, and I think I can help.
Okay, please do. But so we're all looking at the same thing to include Mr. Lee. I am focused on.
Yes,
that was a bad job of drawing, but that number right there, which if your screen is too small, is $12,336. But you said 15,000. This ledger reflects some attorney's fees. It certainly reflects the differential. Here's the monthly assessment, $253, and Mr. Lee hasn't updated his monthly payment, and so he is falling behind every month, not only because of late fees and interest, and that interest number is now almost half of the monthly assessment, but he's falling further behind because he's paying on a monthly basis last year's assessment amount and not this year's. We could talk about that.
Could I say something?
Not yet. You may not. Connect the dots, because it's a $3,000 difference, and that's meaningful in this situation.
Absolutely, Your Honor. And it has more to do, I think, with the method of my presentation as an attorney than it really does to do with the account ledger itself. And the reason I do it this way is because of the problems that you pointed out, that the property management companies are trying to keep a real-time balance, but it's completely imperfect because I'm incurring attorney's fees right now as we speak, and they're not immediately entering it on that ledger. So what we opt to do instead, and what Ms. Fox has testified, is that the total number of assessments, the total amount, if you just went line by line and added everything that is labeled assessment, that raw number adds to $15,251.90.
Got it.
That doesn't take into account anything else, no payments, no assessments, nothing else other than the assessments themselves. So that's why the number doesn't match, because this ledger also shows late fees and interest and some attorney's fees. And then it's got payments on it. This number at the bottom of the ledger, to me, really is meaningless without context of sort of how we arrive there.
Well, but you say meaningless. It should reflect pretty darn close to the amount Mr. Lee and his wife owe, minus, meaning it doesn't include, it will get bigger, the additional attorney's fees. Because I'll note, if I go back to this document, if I can move it, it's not moving. Got to get out of this drawing thing. If we go back, there are some legal fees in here, and not all of them, because as you mentioned, you continue to accrue them on behalf of your client. But the $12,000 figure ought to be kind of close to what you're seeking to collect, because it's got late fees, et cetera. But I now understand your point. The $15,000 would be if we simply added up all the line items in this ledger that are assessments.
That's math, Your Honor, and I agree with you. It should roughly represent what's being sought. So we'll go through this real quick. Take a look at 5/18/2021. And this is really rough. I'm doing this on the fly.
Okay.
And lawyers doing math is always scary.
Yep.
But 423.72. Do you see that charge for legal fees?
I do.
Okay, now scroll down to 7/23/2021.
Yep.
Do you see the charge for $1,549.43?
I do.
Roughly, that adds up to about $2,000 in legal fees, correct?
Yep.
Today, Your Honor, I'm seeking $5,200 in legal fees alone, not inclusive of costs.
Yep.
There's your difference.
No, I understand. We're aligned. I get it. I just didn't, when I heard that 15,000 number, I didn't appreciate, I do now, that's just the gross assessments. It's not net, because it just wasn't the amount that reflected that actually Mr. Lee's been paying a whole bunch. And you've always said that, hey, the guy's been paying. He hasn't been paying enough each month recently. There are a bunch of months that were missed, and Mr. Lee can blame Wells Fargo, but that's not Piedmont Heights' problem. So I'm understanding now why 15 and 12 are different numbers.
Any more questions, Your Honor, for Ms. Fox about the account ledger or anything like that? You understand now sort of our method of presentation.
I do. No, I appreciate Ms. Fox's testimony. I'm sorry I mislabeled her as court reporter.
It's okay. Thank you.
You bet.
May I, if there are no further questions for Ms. Fox, may I present the attorney's fees now?
Actually, let me give Mr. Lee a chance. Mr. Lee, did you have any questions for Ms. Fox? You and I will have a conversation, but did you have questions for Ms. Fox while she was testifying?
I do have a question that I make a payment every year, except some reason the thing it fell off in 2017, 2018. And the difference between 2020, because I never get anything letter or any XOA meeting to say the XOA free increase for 2020. I have no information, so I keep paying the same. And I have bank automatic payment. So if they did some reason they didn't receive for 2017 and 18, all they do is just send me a letter, give me a call, because I have my information on the system. So they didn't say anything, and then June of 2021, I got the amount, say 8,000 something. I got to pay, and now it's going up to 15,000.
So I don't know that was actually a question, but I'm going to turn that into a question, Ms. Fox. How does the association typically alert its membership that the monthly assessments are going up?
So remember in the beginning, Mr. Fenimore presented that this property hadn't transitioned from the previous owner's name to the new owner's name. And that's how we communicate. When a new owner purchases a property at Piedmont Heights, they send in the warranty deed or the closing disclosures, and we transfer the property from the previous owner's name to the new owner's name. Since this never happened, we never had a record of Mr. Lee being an owner. So when we send out communications, Mr. Lee wasn't in our system as an owner to receive the document, to receive the notifications that the increases had taken place, when they took place, and even any type of communication, because we communicate a lot via e-blast and regular snail mail.
Okay, so Mr. Morrison may have had an email in your system, email address. Anything you send out there obviously is not going to Mr. Lee. But if you mailed something to the address that we're talking about, this 1413 Summit North, wouldn't that have gone to Mr. Lee? It just would have been addressed to Mr. Morrison?
That is correct. And he may not have answered it or opened it because it wasn't addressed to him.
No,
Okay.
I never received anything until June of 2021. That's
Okay,
why I
well,
see the
you'll get a chance to tell me about that stuff, but I understand your concern. And my guess is now you are pretty closely dialed in with staying in touch with the association so that you will know what the monthly assessments are. All right. Thank you, Ms. Fox. I appreciate that. Mr. Fenimore, if there's anything you want to present on behalf of attorney's fees or anything else on behalf of your client.
Yes, Your Honor. Thank you. I want to point out interest. We filed a document in advance, a compilation, the CS, the demonstrative exhibit. And we've used that to calculate interest, Your Honor, because that calculates interest simply on assessments less payments and not on other things. The interest charges that you see on the ledger, you might expect to add all those up and come up with the same interest number that we're seeking. And I would guess that if you use ours, you'd come up with a smaller number anyway. So
Okay.
What we're going with is this form here and the interest. And I also want to point out something else, Your Honor, little egg on my face on the presentation. Again, I warned you about lawyers doing math. Please scroll down to the very bottom.
Mm-hmm.
You see how it says $15,451.90. That's exactly $200 more than what the witness has testified to. We're going with the testimony.
Okay.
So I'll fix that on any proposed order I submit. I just wanted to point that out.
But there's our 15 figure you were talking about. Forget about the math error.
Right.
And that reflects simply, if you just add up every bill for every month from Feb 1 to 2017 to May 1, 2022, it gets you that figure. And then, of course, we go down to the penultimate line in that first box and you've got payments. And that reflects the fact that for many, many, many months, Mr. Lee and his wife were making payments. They missed a whole bunch, and he's going to tell me about that. And of late, they've been paying amount that is less than the monthly amount, but that this certainly reflects some of the financial efforts they've undertaken.
Yes, Your Honor. You'll also see that the total amount that we're seeking here, the 13,822, is actually pretty close to what's on the ledger as well. So harmony between the two documents, although not perfect.
Yep.
Your Honor, we've sort of established the first 1, 2, 3, 4 lines on this spreadsheet. May I testify regarding attorney's fees at this time?
Yes, sir.
Okay. Your Honor, we filed an affidavit. I'll just go ahead real quick through it. My name is Stephen Fenimore. I'm licensed to practice law in the states of Georgia and Florida. I've been practicing law since 2005. Since 2006, I've almost exclusively represented associations in these kinds of collection and foreclosure matters. Our firm's been retained by Piedmont Heights to represent it in this matter. And our rate has varied. Currently, it is $195 per hour for attorneys and $95 per hour for paralegals. And attached to my affidavit, and in the ordinary course of business, we maintain what we call a settlement statement, which shows the work that we've performed, the date on which we performed it, the amount of time or the flat fee associated with that fee, with that work, and the total amount of fees that we've generated in the case. And with what I filed with the court, we're showing that The total amount of attorney's fees incurred in this case are $5,208. We've also incurred costs in this matter for filing the lawsuit, for effectuating service of process. And the total amount of costs in this case have been $1,010.75. We're seeking both of those amounts, attorney's fees and costs. And I would assert that given sort of the added layers of complexity in this case, the fact that the association and me, who's doing title searches and doing these all the time, part of my practice, had no idea that there were new owners to this property. We ended up chasing Mr. Morrison, who we thought was the owner, only to learn that Mr. Lee, after we had filed the lawsuit, was actually the owner. And Your Honor, you're the trier of fact in this case. The question is whether or not that work was reasonable. And I would submit respectfully that it is. I would also submit that the rate that we charge, the various flat fees, is very reasonable for me, for an attorney who's been practicing 17 years now, which makes me cringe to say.
That's a big number.
An outrageously low rate. Crazy price, Your Honor. So I would submit that the $5,208 that we're seeking in fees is reasonable given the nature of the complexity of this work compared to what other attorneys would charge in the metro Atlanta area, and the costs were necessarily incurred to file the case and to get everyone served.
The 10% interest that Ms. Fox mentioned in response to one of your questions, I assume that is in the declaration of covenants or some homeowner arrangement, so that a unit owner is on notice that that's the rate at which interest will accrue?
Yes, Your Honor. And the declaration, the relevant provision of the declaration, was attached to the as Exhibit A to the request for admissions. So I believe you've got that on record. And also another place you can look, since this is a condominium, is 44-3-109, which provides for a maximum rate of interest of 10% for condominiums. So we got it in two places in terms of notice.
Okay. Excellent. Anything else?
No, Your Honor. I have a proposed order. We'll hear from Mr. Lee.
Great. Mr. Lee, you are up. If there's a way you can turn your volume up a little bit, you're still a little hard to hear. And
right now, I'm in at the maximum volume.
okay, well, we'll make it work. I am happy to hear whatever you want to share with me. I'm going to start with a question, and then you can go from there. I noticed that some of the correspondence, the letters that Mr. Finnemore has been sending you, did not go to Summit North Drive, but they went to Jonesboro Road in Hampton, Georgia. Do you live in the condo, or do you live down in Jonesboro and the condo is an investment property for you?
I live in the condo, 1413. That's where the Piedmont High is. Since I bought the property 2012 up until now.
What's the Jonesboro? What if I went to that address in Jonesboro on in Hampton on Jonesboro Road? Who would be there?
That my family member. I used to live there before I moved to condo at 2012.
Okay, so you and your wife moved from Hampton to the condominium.
Correct.
All right. Are you in the condominium right now?
Yes, I do.
Okay. All right. Tell me what you want to tell me.
So when I purchased the property at Condo, I took the ownership and I registered my name and everything. I mailed in my check and everything to Associate. So I lived there from 2012 until now, 10 years. So some reason I have Wells Fargo automatic payment, and they pay everything except, so I keep paying the same amount because I don't. So one thing, maybe I did not pay, or maybe I tell Wells Fargo to automatic pay. I have to set up automatic pay until I cancel it. So either they didn't pay, or they pay Piedmont High. Piedmont High didn't get the check, or something. I don't know why that happened. So it could be I did one, didn't pay. Two, Wells Fargo didn't send the check out. Three, Wells Fargo send the check out to Piedmont High and they never cash it. So if they don't cash it, it doesn't show up on my bank statement. But I have an automatic payment. I don't pay every month manually. So some reason 5 months in 2017, the whole year 2018 and the difference into 2022. 2022, because I expect to be in the XOA meeting, get a letter and say, anything. Nothing happened. Nothing come to my mail under previous owner on my name. And I have gate, I have check mail in, I update my information with the XOA. So they must have my information. But some reason they changed it to previous address. They send the thing to the wrong people. Could be because they track it from the county website. With I misplaced my document and I working on trying to get it and file it until June of 2017. I get the letter say, from previous owner say, 8,000 something. So I start looking for the attorney, and then they turn around and sue me for that amount. I went through and asking for clearly statement, and they provide me. But from the two PDF I sent in, look like I only have missed 5 months in 2017, a whole year of 2018, and the difference like $12 something different. But now it come up with like $15,000 with late fee. 2020, 2019, I paid for everything charged with late fee, interest, and everything. So I don't know how it come up with that amount. I know the attorney fee because of this, but other than that, I don't know. I live in the same place. I got no letter. I got no phone call. No contact information. Say, hey, you didn't pay 5 months in 1 year. You didn't pay the whole year in one. I got nothing. And then now suddenly.
So why all of a sudden in January of 2019 did you start paying the monthly assessments?
No, I paid from 2012 until now. So
okay, so you paid. I hear you that you paid for a while. Something happened, and starting in 2017, the payments stopped. And I heard you say you don't know if it was Wells Fargo or what, but it's not Piedmont Heights. They're not getting the money. They're not going to get a check and not cash it. They have been accepting your money before. So I am finding, as a matter of fact, that they never got any money for, let's just pick a month. In March of 2017, they got no money from you. And then that continued for a while. But then somehow, this is my question, somehow January 1, 2019, you started paying again. But not only did you start paying, you knew the exact amount. It was a different amount than what you used to be paying. So you must have received some information from the homeowners association because you started paying and it's the correct amount. It's $241.50. I'm gonna share the screen so we're all looking at the same thing. So let's go back to this document, share, and there it is. So I am focused on some way to highlight, I think. It's this. Down here, this figure right, oops, I just made it almost disappear. Oh, it did disappear. That 241, you paid exactly the right amount, which was more than what used to be owed. And I know is more than what you were paying in 2015 and 2016. So Mr. Lee, tell me what happened at the beginning of 2019 so that you knew the amount to pay. I can't hear you now. I can't hear anything. It's zero volume. So I don't know what happened. Maybe you should, whatever you've been spinning inside the headphones, try that again. Nope. It's like it's mute. If you want to dial in on a phone and do it that way, that might be better. We cannot hear you.
Your Honor, I don't want to hijack the flow of the presentation here. There's one thing I would like to respond to regarding notices and where they were sent.
Sure.
I don't know if you'd like me to do that now while we're waiting for Mr. Lee to get back.
Let's do that. Let's use this time because we've
Thank you,
got
Your
about 12 minutes left before I got to go.
Thank you, Your Honor. You'll see that attached, Your Honor pointed out that we had been sending notices to what was that address you mentioned? The Hampton address.
Yeah, Jonesboro Road in Hampton, Georgia.
So two things I'd like to reference. Firstly, Your Honor, if you take a look at the amended complaint, and if you'd like to share a screen with me, I have it on my screen already. I can show you.
Sure. I think you should have the ability to share screen.
Okay. I'm sharing now. Let me know if you can see it.
Yep.
So attached as Exhibit A to the complaint, you'll see that we attached first the deed, right, showing that the property, that the deed wasn't recorded until 2021 of July.
Yep.
But that when we amended the complaint, we had already, prior to amending the complaint, fulfilled our statutory sort of checklist by sending Mr. Lee and Mrs. Lee notice of foreclosure as required by the Act. And when we did so by sending it certified mail, both to the property address and to the offsite address. Now, the statute says offsite address provided by the owner, but we don't leave it up to the owner. We look for them actively to see where else they may be residing to make sure that we cover all bases. And we also send it to the Jonesboro address.
Okay.
So two addresses. And another thing, Your Honor, sort of made this point. I sort of want to just hammer it home. You had suggested that, okay, Mr. Lee, if you were at the property, presumably you would have been receiving notices, even if it wasn't in the right name. Well, you can sort of go back to our settlement statement and see that our work on this matter began in February of 2021. And we send just a very basic letter, only charging a fee of $80 for doing it, to the property address. And we sent it to Alexander Morrison. But again, if Mr. Lee was there, presumably he would have received this letter and maybe opened it. I don't know. And see that there was some issue regarding assessments. And again, at that time, our fees were low. Opportunity to sort of resolve the situation. So I just wanted to respond to that. I didn't know if Your Honor was sort of relating it to the reasonableness of the fees, but we've been sending notices all along to the property address.
Got it. Okay. Thank you. Mr. Lee, it looks like you got your phone. Try talking into that.
Yes. Yes.
Yep. I can hear you.
Okay. That sounds good. So, can you share the document that I sent you, the 2 document or 3 document that I sent you on Wednesday?
So what I have is those documents. You may need to talk to me about what they are. Mr. Finnemore has said he might have an objection to one or more of them, so I really shouldn't look at them. One of them you sent, you've marked up. I'm happy to share that. That's a document that is a demonstrative. Yeah. Let me do that.
Your Honor, to be specific, the document that I'm moving to, that I'm objecting to, is the one that has the bank transactions listed on it with payments. And the reason I'm objecting to that is that it seems to be a compilation of something that's not in evidence. We have some case law that's actually pretty cool to have in the realm of associations called McCarter versus La Hacienda that talks about an owner who is trying to admit copies of checks. And the court in that case ruled, no, these are not admissible evidence. You would need someone from the bank to authenticate them. So same issue here, but then sort of just talking about what that document is, it only shows things that are already on the ledger, and it doesn't cover the period that he didn't pay. So I don't really think, even if you were to look at that it would create, this is not an MSJ, but a genuine issue of material fact regarding the dispute.
Right. It's proof of payments already accounted for. Are you referring, I've got 3 items in my defendant's exhibit folder.
Right.
One is an Excel spreadsheet. One is your document, your CS 55-2022, but it's been marked up. And then there's something called bill pay history. Which is the one you're objecting to?
I don't know if you have color. It's the Excel sheet, I think, is really the one I'm referring to.
Okay. Well, I'm not going to look at that right now. What I do want to share is this, at least, so that if Mr. Lee wants to walk us through some things, he can do that. This is your exhibit, Mr. Finnemore,
Yes.
but it's got some annotations or markings that make it still demonstrative. Perhaps it depends what Mr. Lee wants to do with that. But this document, Mr. Lee, if you want to talk to me about this, I'm happy to let you do that. The other documents you're talking about do contain hearsay. If you've got someone from your bank here to authenticate your bank records, then I can look at that. But if you don't have someone from the bank or other filings from the bank saying these are what Mr. Lee says they are, then I should not look at those. Okay?
Sure. So when I got a note from the attorney say that I didn't pay, so I went back and go to the bank and asking all that I can go back to the payment history for 2 years. So 2020 and 2020 and 21 is, but it doesn't, so that means I have a record I pay, automated through the bank and when the check clear, but that doesn't say anything to 2017 and 2018. So this is the document he sent. So this he sent lately, and it's more clear to me. So I went through every month, and it looked like 2000. He didn't have 2012, but he started at 2017. So I missed the payment. That's all. And
well, and the reason they started with 2017 is because that's when you missed some. They're not trying to collect things that you paid, and you've told me.
So I agree. Okay. So it looked like my breakdown. I owe 5 months in 2017. I circle and mark it.
Yep.
And then the next pay, the whole year, 2018. So
yep.
To me, it looked like 4,000 that I didn't pay.
Okay, yeah, but along with not paying that, as long as you're not paying it, you are accruing late fees and interest.
Correct.
Okay.
I mean, yeah. So I'm asking if they can void them.
Okay. So what's
like
tell me what the disagreement is?
But if you look at 2019, you look at 2019, 18, everything I pay the same amount, but they charging late fee, they charge everything. If you're looking at the column next to the red box, it's the late fee.
Yep.
Everything I pay $241.50. I pay $241.50. So why the late fee? Why that? Where did it come from?
I'm not going to provide a huge answer other than to say, as long as, well, I don't know about the late fee. Maybe Mr. Finnemore can explain that. But the interest is going to keep accumulating. You owed them money for the 17 months you missed, and if that's $4,000, whatever the number is, it's going to grow by 10%.
Right. So the next Excel sheet I come up with like 39.58, and then with 10%. That's all. I mean, the reason is I didn't get. I mean, why do I pay every year from 2012 into 2020, and I did not pay anything like that? I got a job. I didn't. So something happened that I did not know. So I automatic payment the same amount. I tell my bank to pay the beginning, and they take a few days to cut the check and send to the Piedmont High. So why this late fee? I mean, this if I get it early from the attorney, like last year, I will take care of it. But the detail is so, and then because the court thing. So I said, but I went back to the bank and asked for a document and everything. I went through my bank and checked every statement, and that's what I missed. So.
Okay, let me stop you. Let me stop you. I have a question either for Ms. Fox or for Mr. Finnemore. Help me understand late fees. And we're sharing a screen right now. The late fees generally look like they're 10% of the monthly amount.
Your Honor, may I respond?
You please.
Okay, so and you might want to share screen with me again. And I mentioned this before, and we can also knock out two birds with one stone.
Great.
Share my screen again. So attached as Exhibit A to the requests for admissions that were served upon both defendants were the relevant provisions of the declaration to which no one has objected. These are deemed admitted. So on the record, we can take a look at the relevant provision of the declaration regarding assessments. And you had asked about interest rate, are there authority? And I said, yeah, it was 10%. And here it is. Here's CI 10% per annum, higher rate allowed by the act. So 10%. Regarding the late fees, Mr. Lee is arguing that, hey, well, I was paying timely in 2019, so there shouldn't have been a late fee. But the problem with that is known, and some declarations have this and some don't, but it's what's known as a application of payments provision, where part of assessment related charges is made. The amount received may be applied first to costs and attorney's fees, then to late charges, then to interest, then to delinquent assessments, then current assessments. Okay. So everything else gets paid first before that assessment. He's making these payments, but the account is already delinquent. The association's position would be that under the declaration, that assessment is not being paid at all. Therefore, it is late. Some attorneys like to take this even further. They like to say, well, okay, well, he's paying, but I have attorney's fees. I'm going to hide the ball on my attorney's fees and say that my attorney's fees are X when they're really Y. We don't do that. That's why I break out. This is the reason why I break out payments separately. But, the use of this provision, I think the way we're using it is correct. Before I was even involved, the association doesn't need to stop late fees on months that he's paying an assessment on time and then start them again on months where he's not. So that's what this provision is used for, application of payments. That's why there's late fees in 2019, even when he appears to be paying those timely.
So I get it. That is a tough provision, but it says what it says. Couple questions then about that. Let me share, if you'll unshare.
Sure.
Why for, there's a weird echo in here.
I had to turn up my volume because I was having trouble hearing Mr. Lee. I'm sorry. I'll dial it down.
No, that's okay. We'll figure it out. So why is this amount 4808 and not 2415?
Your Honor, that appears to be wrong. I guess if you look at the one below it, 2415, and then the one above it is also 4607
and 4406, 4403. So some of these
are doubled up. You see November and December were both missed, so perhaps a catch up. January and February, there's only one, so those are combined perhaps.
Maybe, but none of them double. 2415 doubled would be 4830 and 23 double would be 46. Those aren't what those numbers are. Curious about that. And then I noticed in here, there are no late fees assessed and no one's obligated to do that. That is, I guess, a windfall for Mr. Lee, but any reason why for several months in 2020, there were no late fees assessed?
I know a lot, Your Honor, but I don't presume to know how accounting software of the management company works. I don't know why they're not in there. Okay. I'm not seeking them.
Okay. This reflects what's being sought. It's Mr. Lee won't be confronted with, oh, you know what? We forgot to put a 2415 in for April and May and June. It's not in here. He's not being charged for it.
Correct.
Okay. All right. So, Mr. Lee, I better understand why the late fees are still being assessed. The condominium agreement, the declaration has some provisions in it that are very, very favorable to the association. But when you purchased the property, you became subject to those provisions. And what they are viewing each monthly payment as is paying off this outstanding balance right here. So let's just look at January 2019. You owe $241.50, your monthly assessment. And by golly, you paid it and you paid it on time. It's in the first 15 days. But unfortunately for you, in January, you had a balance coming in of $5,000. And so they credit the $241.50 to this and it is not deemed a payment of your monthly fees. And so in theory, they could hit you with a late fee. I picked a bad month because they didn't, but that helps me understand why late fees continue to accumulate. And that may seem unfair to you, but it is the natural implication of the language of the declaration that governs every condominium at Summit North.
My question is, there ain't no communication between Piedmont High and me. Say, hey, you didn't pay. You didn't pay for a year and a half, 17 months. There ain't nothing coming to my mail. Previous owner, my name, nothing. So I just have the bank pay the same amount until I know something wrong.
So you didn't have the bank pay the same amount. Somehow it changed. But I hear what you're saying, that you feel like they didn't communicate with you. I'm finding that they did give you notice once they knew who to talk to, but they didn't know who to talk to early on. Everything they did at the beginning was for Mr. Morrison because you hadn't filed your deed.
True, that's on my part. I bought a few property, but whenever I do that, this foreclosure is the first time I do. So they didn't take care, so I did not know. I misplayed the documents, so I didn't file. I will file after this, but I still got to work to get the document and everything. That is my fault on that part. But
okay.
I live in the same place, so no mail, no nothing. I mean, I supposed to get invited into the XOA meeting every year, and every year by December I go in there and just look at it. But I don't. If nothing wrong, I just keep going. Do the
since this lawsuit, Mr. Lee, have you gone to the HOA and said, "Here's my email address. Here's my phone number"?
No. They have my information. They have my information on the check on the system. They have. Ms. Fox indicate that my name and everything in there. It's just the deed that I didn't file. And when they sue, they tracking the owner based on the deed at the county.
Well,
but
because they have to sue the owner. They can't sue the occupant. They have to sue the owner.
Right. But they know I live in this place from the time I bought. They have all my information. They have my phone number, my anything, because the gate information.
But the person who lives in the place is not the one who's responsible. It's the owner who's responsible. And the way they learn that's... Okay. But how are they supposed to know that until you file your deed?
Right, yes.
So here's my thought, Mr. Lee. You're going to do what's in your best interest and your wife's best interest. You may want to reach out to Mr. Finnemore, and if you don't have his phone number, it's all over those letters you got.
No, I have his information. Yes.
Good. You may want to reach out to him to say, Mr. Finnemore, it looks like I owe some money. Is there a plan we can arrange where I start paying it back? It may not be everything at once because, like you said, you're working hard, your wife's working hard, and if you had $1 million, you'd just give them the money. But neither you nor I have $1 million.
Yeah,
so
I pay every year. Why should I skip, and get all these problems? Yes, I will try to talk to him, but it seems like he's very strong on the amount that he has. So my calculation is $4,000 with 10% interest. I mean, it doesn't come up with $15,000.
Okay. Well, I understand your calculation. I also understand Mr. Finnemore's, which is supported by the evidence that I've received, which is why I'm encouraging you, if you want to, it's your choice. This is not a directive from me, but I'm encouraging you to reach out to Mr. Finnemore to see if there's some middle ground you guys can reach. But I'm going to be entering a judgment later that makes clear how much I have found you owe. And if you and Mr. Finnemore don't reach an agreement, Mr. Finnemore does have the authority to start trying to collect on that, which could include foreclosing on the unit. But I heard Mr. Finnemore say very clearly, that's the worst outcome for everyone, and that is not what he's interested in doing. Okay?
I don't want that to happen, so I'm just depend on your judgment, and you set the amount. that you think is fair for me and for the people.
Well, I want to say this, Mr. Lee. I don't get to decide what's fair. I've already told you that provision in the declarations seems like it probably favors the association more than the owner, but that's what's in the declaration, and I cannot change that. That's where these late fees keep coming up. I can't change the interest rate. A 10% interest rate is about 10% more than I get on my checking account. But that's just the reality of the arrangements that the people who purchase units at Summit North make with the association. So my order, my judgment that I enter is going to reflect what I think the law says and what the evidence says. It may not necessarily be what I think is perfectly fair because you've made these good faith efforts. Where fairness comes in will be you talking with Mr. Finnemore on behalf of the association to see if there's a fair middle ground you guys can reach where you commit to paying things down more than you have been, and they commit to keeping you in your condo because it sounds like you're a good neighbor.
Yes, I do. I mean, I really like the play. I don't want any foreclosure or anything, and probably I don't have the amount to pay at one time, but I will come up with a payment, maybe hopefully within 6 months if they allow me to. And Mr. Fillmore, that it looked like I only missed 17 months. Are you agree on that?
So we're not negotiating here. I'm just taking the evidence and I'll enter an order. Once I've done that, then you two should start talking because then you know what the framework is. Okay.
Sure. Yes, sir.
All right. Did you have anything else you wanted to share with me, Mr. Lee?
No, only the document I sent in, but that's fine. Yeah.
Do you feel like you've got Wells Fargo doing the right thing now with your payments?
Well, when I know that I miss a payment, I say impossible. So I track in, but all they can provide me, they say I can go back 7 years for a bank statement, and I can only go back to automatic bill payment history 2 years. So that's the 2 years that I send in that I have XOA for other property and everything. And then the statement I can go back to 7 years. Bank statement I went through and looked like I missed those. So will that be okay? Some reason later on, let's say a year from now, 2 years from now. I mean, they don't provide me. They just don't help me on this thing. Even though I say I have a suing, I have a court thing, and I need a document and everything, but they seem like doesn't help me or either online or at the local bank office. So let's say if by some reason I come up with the thing that I have a bill payment history that I pay for that month, and then do I go back and get the difference?
Well, that'd be a discussion for you and Mr. Finnemore. Right. It doesn't sound like the payments went through. They're not showing up at Piedmont Heights. And like I said, they've got no interest in not taking the money. Let me do this since we're wrapping up here in terms of time.
Yes.
You should, Mr. Lee, make sure that your monthly payments now in 2022 are the correct amount, because if I look at the spreadsheet, you are still paying $241.50 every month. That is not the monthly assessment. So you're sliding further behind.
Right. I'm short in $12.08 every month. And
and that's only adding up and making things worse for you.
Right. Sure. Yes. I don't want that to be happen. Now I know the problem and everything. So.
All right. So please reach out to Wells Fargo and bump that up. And then you really do need to file that deed and then get with the association to say, look, I'm the owner. I need to be the one who gets any notice about anything in connection with this unit. Okay.
I think they have my information. They have my deed. The attorney and Piedmont High, they have my deed. But I need to file. I need to get the document and file. Yes.
Handing them the deed is not the same thing as filing the deed. So
Your Honor, the deed has been recorded. There's no issue there. In fact, the lender did it and I did it too. It might be recorded twice.
Great. That's better than zero.
But Mr. Lee does need to, the fact that I know where he is and how to reach him doesn't mean the association's been requested to update their records. So that still needs to happen.
Right, right. So, Ms. Fox, what is the best way for Mr. Lee to get in touch with someone who can look in the system and say, great, it now says Brandon and Tracey Lee. Here's the email address. Here's the phone number. Who's the right person for that?
When that is complete, he'll receive a letter in the mail, and that letter will have information about our portal, and the portal is called Vantica. It'll give him login information and everything. And from that point, he has the ability to log in and change and update anything he needs to in reference to his account.
When what is complete?
Oh, I'm sorry?
What you said, when that is complete, when what is complete?
When the transition, because it's not still fully transitioned from the old owner to the new owner. So once that transition is complete, and I'll personally be sure that that is complete. Once that is complete, he receives a letter and that tells him how to use Vantica and how to get into Vantica. And at that point, that's when he enters and checks all of his information to be sure that it's correct and update anything that he sees an error with.
All right. So first of all, your nails are fantastic. I really like those. But second, what needs to be done to complete this transition that you're describing?
I have it. I have his warranty deed, and I am sending it in the system today to have it transferred from the previous owner to the new owner. I will personally walk him through this, and I'm glad to give him my phone number as a follow-up to be sure it's taken care of.
Great. If you want to put that in chat.
Please.
Good.
They have it. They have my information.
Well, but what I'm hearing, Mr. Lee, is because of this extremely late recording of the warranty deed years after you moved, it's only now moving through their system. And Ms. Fox is going to give you a phone number. I see it there now in the chat. You should write that down and circle back with her in a few days.
Yes.
Once the system, the homeowner's system reflects that you are the owner, it sounds like you'll get all sorts of information about how to make payments, check your balance, etc., so that going forward, you don't fall further behind. Okay?
Yes.
Great.
But they also unlock my key to get in the gate for Tracey.
All right. Well, you talk to Ms. Fox about that. I'm not going to get in the middle of that.
Sure.
Mr. Finnemore, do you have anything else on behalf of your client?
No, Your Honor. Would it be okay if I submitted to Ms. Niles a proposed order in Word for you to look at, review? And I'll go ahead and I'll make the mathematical corrections that we sort of discussed in the hearing. And then, but other than that, you can, of course, you'll modify as you see fit.
Right. Yes, please back out the 200 and do get it to Ms. Niles in Word format.
Thank you, Your Honor.
All right. Mr. Lee, anything more from you?
No, sir. I'm good.
All right. Well, thank you. Ms. Fox, nice meeting you. We will be adjourned. I'll look for that proposed order and take it from there. Good luck, everyone.
I appreciate your time this morning.
Same.
Thank you.
Bye-bye.
Nice to meet the invisible Ms.